Good morning. This is Chair French, and I'm convening this special business meeting of the Kansas Corporation Commission for this Friday, February 9th. Happy Friday, everyone. I am joined by Commissioners Keene and Keither. The purpose of this meeting is to discuss a legislative matter. I believe you are all aware of a bill that has been filed in the House Energy Committee, and that is House Bill 2591. I'm pulling it up here to remind myself of it, but essentially this is a bill that would impact the KCC and our processes. It does two things. One, the first piece of the bill provides an exemption for the KCC with respect to an exemption from the Kansas Open Meetings Act with respect to matters relating to docketed proceedings before the commission. Essentially, it would allow the commission to deliberate when we are in those court-like proceedings. The second thing that it does is it would expand the type of proceedings that ex parte prohibitions apply in beyond just adjudicative dockets into all docketed matters, which would include things like general investigations. It also provides some additional clarifying edits to that ex parte statute and provides a definition of what an ex parte communication is, which seems like a helpful add to that statute. The reason we've called this meeting, or I've called this meeting, is this bill obviously impacts our agency. These two provisions are specifically triggered by our proceedings and aimed specifically at us. Typically, when we testify at the legislature on bills, our staff just goes and testifies to tell the legislature about the impact. However, in this case, because the bill directly impacts our processes, and we're not just providing technical advice, I thought it would be appropriate for me as commission chair to go down and testify on the bill. And frankly, we probably need to go testify because we have all the facts about how our processes work and how this would impact us. So what I have done is I have prepared some testimony. I believe it has been circulated to you all. The latest version, I think, was circulated this morning. What it is it's neutral testimony, but I want to run through it a little bit here and explain. And then if we want to take any action to authorize me to make that testimony on the commission's behalf, or if I don't know if I need a vote, if it's just me going and making it on my own behalf, but I certainly wouldn't mind if the other commissioners want to bless it. But maybe if you would allow me to just run through at a very high level what I would plan to testify to, and then we'll open it up for any discussion, or if anyone wants to take action, make a motion, we can do that. So essentially, as I said, what I want to do in the testimony is explain, what we think it would do and how it would impact us, and perhaps any benefits of the legislation, although we would be neutral. So the first thing I do in the testimony is just lay out what I've done for you here earlier, which is technically what would it do? The Open Meetings Act exemption in sort of our court-like proceedings, and then the expansion of some of the ex parte prohibitions in our docketed proceedings. And I think, I will explain that we're going to be neutral on the bill. We're not advocating for its passage. And I think the key to that is, even though I'm going to get into it in a minute, that I think there are some benefits to the bill, I think it's important to point out that even if it was not passed, we could still effectively carry out our statutory duties, with or without the proposed amendment. And so I think that's the reason why we would be neutral on the bill. the other things but I think the meat of what I would want to lay out, maybe it goes more toward the COMA exemption. I have worked both inside the building for a lot of years and outside the building, and I've been a stakeholder. I talk to a lot of our. There have definitely been some concerns, and I think frankly surprise from our stakeholders that the commissioners can't talk to each other, or choose not to talk to each other because we think there's some ambiguity of whether the COMA applies in those docketed proceedings. There are concerns that maybe our decision making is not as fulsome and thoughtful as it could be if we were able to talk. I don't know that I agree or disagree, but there has definitely been a concern raised that our staff might wield undue influence by the fact that commissioners don't directly speak to each other, that essentially staff coordinates all the decisions. And so that I know that's out there. I do think there are some merit to some of those concerns that have been raised. I do think that we should probably, or at least from my perspective, it would be good to provide the feedback to the committee that this bill would aid us in making our processes more efficient. It would be helpful to have that ability to, just like a court does, once we hear all the evidence, to be able to deliberate on that evidence directly. Also because the matters we here are so technical and complex, it would be good to have sort of a private vetting of those issues, be able to explore them openly and candidly between ourselves. So I think those are some benefits that I would put out there. One thing that I personally might want to emphasize is that I don't think that this would have any would really undermine any of the sort of the public policy rationale behind the open meetings law. We are subject to the Kansas Administrative Procedures Act. We're subject to the Kansas Judicial Review Act. Our proceedings, once they become docketed, they are truly judicial in nature. As we see in the bill, we're subject to all the ex parte prohibitions. We are subject to due process protections. We're subject to judicial review. We cannot, because of that judicial review, we cannot act arbitrarily. We can't act contrary to evidence. So, just like a court acts, we're subject to all those strictures. I think it's probably universally accepted that the courts benefit from that ability to privately and candidly deliberate the matters before them. And I think that same rationale would apply to our docketed matters. And again, to emphasize, this would not be, as I read the statute, not a full exemption from the Open Meetings Act. This is an exemption only in court-like proceedings that we undertake in our docketed matters, where we hear and receive evidence and then need to deliberate on that evidence. So everything I've said here is essentially what I have drafted up as testimony. Again, also would emphasize it's neutral because I think we can continue to carry out our mission, fulfill our statutory duties without this. But certainly, as I explained, I think there are some efficiencies and benefits to the legislation that we could highlight for the committee that probably other stakeholders may not understand as intimately as we do. So with that, I would open it for any discussion. If folks are comfortable with what I've laid out, you could simply indicate that you're comfortable with me making that testimony, or if you would like for me to make it on behalf of all three of us, I would entertain a motion to that extent. But let me just open the floor for any discussion.
Well, I have a thought. I think they're very specifically going to ask you why we're neutral. So I think, that will help lead into your good explanation of why you think it helps us do a better job. Which, being the newest member of this commission, certainly I really hope they do allow this, because it would it would definitely be more beneficial, and I think it would allow us to do a better job. I've been very frustrated by this. Not, I'm coming from a place of talking to so many different people and not even being able to go next door, a couple doors down, to be able to talk to you guys has been extremely frustrating. Not to tell me what to do, but to have a conversation and see a different point of view. And that's beneficial to making a decision. So they'll ask you probably why we're neutral. So I think that does lead into a good discussion, and I think you should be the one to do it. And so I will move that you go ahead and testify in front of the Energy, Telecommunications, and Utilities Committee on Tuesday morning.
All right, thank you.
Well, thank you, Commissioner Keither. I concur on all those thoughts that you had. Andrew, Chair French, thank you for the overview. I appreciate that very much. It was
There's
good.
There's a motion on the table. Excuse me.
I'm going to propose to amend your motion, Commissioner Keither, if you see fit.
Sorry.
All right.
The old part of me coming out. Sorry.
I'm kind of winding up for the pitch, as it were. What I think is important is that we go forward as a unified front, as a commission, because I think we're all three on the same wavelength. I think we're all three somewhat empathetic to the goals, certainly, that this bill seeks to achieve. And I think it's important that we not be tepid in going forward collectively. So toward that end, Commissioner Keither, if you would consider an amendment to your motion, toward that end, I would move that the commission authorize the chair to represent all three commissioners in offering testimony on behalf of the commission on House Bill 2591 before all necessary committees of the 2024 session of the Kansas legislature. That's the motion.
That's much more succinct than mine. So yes, I would agree to that. But
So
we need
so I believe then it is Commissioner Keither's amended motion. It was a friendly amendment and you accepted it. So do we have a second for that motion? I guess I'll second it. Any further discussion on the motion?
I think
I'll
add one other thing parenthetically here, Chair French. I think obviously we have complete faith in your ability to do this on our behalf. And I think it's important that we convey not only having the faith in your ability and you're doing that for us, but that, as I suggest, and I'm being terribly redundant now, that we have a unified front here, and that we're not just putting you out front to represent us, that we're with you wholeheartedly. Having said that, I have no further comments. Thank you.
Well, I certainly see the benefit of having a unified position. I don't want to ever go, even though I currently am the chair, I don't ever want to go testify on something that the commission is uncomfortable with. And in this case, I can represent that our position is truly tripartisan, if you will, with a D and an R and an unaffiliated. So that's about as broad a spectrum as you get. So I appreciate the feedback from both of you. Well, with that, I guess we do have a motion on the floor and we have a second. And if there's no further discussion, I will just call the vote. All in favor of the motion as stated, please vote aye.
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 Aye. Any opposed say no. I don't hear any no's. The motion is approved. I don't think there's anything else on our agenda. This is a special meeting, so we kind of have to stick to the agenda that was put out there. So I'm not going to even ask if there's any more business, although I will present one more piece of business, and that is just go Chiefs. But with that, I would entertain a motion to adjourn.
I move that we adjourn.
Okay.
Motion and a second to adjourn. All in favor, please vote aye.
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 Aye. We're adjourned. Thank you all. Take